Okay. All right, so the meeting has started recording. I'm going to go through the agenda really briefly and then move into the slide deck that's been prepared for this morning's dialogue. And I will go through the slide deck pretty quickly to allow us to spend as much time as possible in the short period of time that we have together to engage in that dialogue. So again, we are starting just a few minutes behind schedule. That's all right. We'll move into introductions as soon as possible, and then start panel introductions at the same time. And then we do hope to start the moderated panel discussion promptly at 10:20. So I'll go through the slides as quickly as possible again. And then we'll have opportunity for folks in the audience to pose questions to our panelists. We'll start that at 11 a.m. unless the dialogue goes over by a few minutes, which often happens because it's an interesting topic. And I know that there's a lot of varying opinions and ideas and thoughts, and that's what we're here to share today. And then we'll close down at 11:30. So without further ado, I'll move into our PowerPoint here. All right, so again, this is the deliberative dialogue session 4 concerning evaluation of THC compounds. Glad that you decided to join us this morning. We will promptly end at 11:30. So our overall meeting goal today is to build an understanding of how we might determine and define what THC compounds are and are not comparing. And our intentions today are to continue a series of dialogues that we started last year at this time concerning plant chemistry perspective. We also want to provide an opportunity for genuine, respectful, moderated dialogue between all participants. And we're going to use the outcome of this dialogue to inform evaluation of THC compound policy and rule development. So why are we here today? LCB issued a policy statement last April concerning THC compounds other than Delta-9. We adopted a new rules section over the summer concerning evaluation of THC compounds and defined terms like additive, solvent, ingredient, and so forth. We proposed legislation in 2022 that would have added additional definitions, but that legislation did not advance. And so, again, we'd like to continue that dialogue towards the goal of trying to understand how we might regulate these emerging compounds. So the data that will be collected today will be added to a Excel workbook, and then we organize it by theme, and we analyze it to kind of lays the pathway moving forward for us. We do share these comments with our board directly, and we'll share the comments on our outward-facing webpage, along with the recordings of these meetings. And those meetings are available, the previous recordings are available on our outward-facing webpage right now. This one will be uploaded in the coming days. So I want to talk briefly about participant roles this morning. We have our esteemed panelists here this morning. I'll be moderating the conversation again. I'm Kathy Hoffman. I'm the Policy and Rules Manager for LCB. And then folks in attendance are active listeners and then participants starting at 11 a.m. So we're looking forward to engaging with you in that way at that time. So I want to just touch briefly on deliberative dialogue. For those of you who've been with us before, this is probably a little boring to see this once again. But deliberative dialogue does differ from other sorts of public discourse. And really, we're here to think together, to learn together, listen to different points of view. And we really are searching for points of agreement rather than points of departure to help inform our work moving forward. All right, and then this is just a comparison table of the difference between a deliberative dialogue and a debate. And of course, again, we're not here to debate. We really are here to find common ground, listen to find meaning, and weigh different alternatives moving forward. So some ground rules for deliberative dialogue. Can't win a deliberative dialogue and there isn't a right answer. We really ask that folks be open and listen to others, especially when your ideas don't necessarily align with each other. We're just, again, looking for common ground and hoping that everyone can respect all the differing points of view that we might hear today. All right, so in terms of format, we'll start again with the panel introduction. Each panelist will have an opportunity to briefly introduce themselves, and then we'll start the moderated dialogue with the panelists. So participants are in listen mode at that point, and then there'll be an opportunity again at 11 for participants to become part of the conversation. If you'll use the hand raise feature, we really appreciate it. Let us know if you have a question, and Audrey Basic, our rules coordinator, will call on you either to share your comment live, or if you've added it into the chat box. And then participants will be called on in the order received. All right, so we'll go ahead and move into the introduction section. So in the chat box, if you'd like to identify who you are, who you're affiliated with, if you feel comfortable in doing so, and why you're interested in this topic this morning. And then I'd like to move at the same time into our panelist introductions. So we'll go ahead and start with Ms. Jenkins, please. I think you're muted. Okay.
There we go. Good morning. My name is Sherry Jenkins. I am the forensic technical lead for all of the chemists for the Washington State Patrol Crime Laboratory. I have been with the WSP Crime Lab for a little over 21 years. Part of my responsibilities are making sure we meet all of our accreditation standards. And when we bring new methods on board, I am part of the validation process. So in 2012, when I-502 passed, we needed to bring on new methodology for testing at the crime laboratory in order to make sure that we could actually do the testing to meet the definition, the new definition of marijuana that included the 0.3% THC. Since 2013, I have been actively analyzing marijuana cases and testifying in court as necessary.
Great, thank you, Ms. Jenkins. Dr. Milburn. I think you're muted. Sorry.
Hi, I'm Mike Milburn. I was a psychology professor at the University of Massachusetts, Boston for 40 years. I retired about 7 years ago and then failed retirement when I created the Druid impairment measurement app that grounded in cognitive neuroscience that measures impairment from any source in about 3 minutes. My interest in that was driven by the legalization of cannabis in Massachusetts and the idiosyncratic reactions to THC that different individuals have. So it was a matter of measuring cognitive motor impairment by measuring actual cognitive motor behaviors like reaction time and so on.
Great, thank you very much. Dr. Northrop.
Yeah, my name is David Northrop. I'm manager of the Marysville Crime Laboratory of the Washington State Patrol Crime Laboratory System. I've been with the crime lab for a little over 30 years now. I also function as the management liaison for our materials analysis group of chemists for around the state for all the laboratory. And part of my responsibilities involve ensuring that everybody in our materials analysis section is aware of the various legislation that's being proposed and how that impacts the work that we do. I am also an analyst myself, although I don't have a whole lot of time to do casework these days. But in particular, I've been tagged with tracking, various legislation that may involve the crime laboratory system. And so certainly our interest here is seeing how the proposed legislation for regulatory purposes interfaces with the legal definitions. And so that's sort of our reason for wanting to be involved in this discussion today.
Great, thank you very much. And then last but not least, Dr. Loveridge. I know you've had a little bit of technical difficulty. Can you hear us? All right. Audrey, perhaps.
He's on mute.
Yeah, he is on mute. All right, Dr. Loveridge, can you hear us at all? All right, so we'll come back to Dr. Loveridge. I wanted to pause here really briefly and hand the floor over to Justin Nordhoff. And it looks like Dr. Loveridge has just unmuted.
Are you calling me?
Yes, we are.
I'm having a very hard time hearing any of the dialogue, so I'll be very brief. I'm emeritus professor, Regents professor at Washington State University. Came in 1977. I've been studying cannabis policy prior to legalization in 2012, and then we had a National Institute of Justice grant to study the impact of legalization on law enforcement, the courts, and correction systems in Washington and Colorado. So we spent 3 years interviewing many prosecutors, detachment sergeants and captains and district commanders and so on in law enforcement, local and state, to try to understand the challenges for impairment determination for officers who are trained to identify alcohol impairment but have a very difficult time identifying impairment from other sources, particularly cannabis sources. So that's the background I bring to the discussion, and I've been working with Dr. Milburn for I think 3 or 4 years now together, collecting field data on the instrument that he's been trying to develop to provide everyone an ability to determine whether they are impaired against a particular baseline, their own baseline, after taking a substance for recreational or medical use. So that's the totality of the background I bring to the conversation. I hope you can hear me better than I can hear everyone else. Thank you.
We can hear you just fine, Dr. Loveridge. We can hear you just fine. We can hear you. Thank you. All right, and just briefly want to pass the mic, I guess, over to Justin Nordhorn for a few comments before we get the dialogue started.
Yeah, good afternoon, everyone. I'll keep this short. So thank you to the panelists for joining us today and talking about this topic. A couple of the issues that we've had in the background of this is through the legislative process last year, we had introduced a bill to try to figure out an effective way to regulate cannabinoids that are other than Delta-9, essentially, that could create impairment. So that term impairment has come up a number of times. The agency is actually considering not trying to utilize that term, but really the question becomes, what type of substance should we be trying to bring into the regulated market that should be age restricted and that might be an impairing substance? Because as we know, not all substances that can be impairing do impair you depending on how much you consume. So I'll kind of couch it as that. The other thing that I want to share with folks is we are hearing some background noise. So if we do, I'll probably be muting some folks. So please, if you're going to speak up, especially our presenters, If you take a look at your mute before you speak, that way you can turn it off, because I can't turn it off, but if we have too much background noise, I'll have to put the mute on so we can hear the other panelists. So thank you so much for being here, and we'll try to keep the conversation moving so we can get done in a timely manner. Thank you.
Great, thank you very much, Justin. And with that, I just want to take a moment to welcome folks from the Washington State Patrol Toxicology Lab. Hope to continue dialogue with them as well, but invite you to provide your comments and questions you might have in the chat box when that time comes. So we're looking forward to engaging with you in a robust way today as well. So let's go ahead and get started. This is a question that we posed to our panelists so far from the scientific perspective and now to you. How might we determine and define what is and is not impairing? I know that's a big question. And so I'm not sure who'd like to start off with giving a little bit of feedback and ideas around whether impairing is the right approach that we need to take, or if there's something else we need to be looking at. But from your perspective, how might we do that? And why don't we start? Dr. Northrop, would you like to kick us off?
Well, I was going to try to throw the mic over to Dr. Milburn, but so certainly our interest, I guess, first off, I want to say we certainly recognize and absolutely support that aspect that if there are compounds that are impairing or are causing, social issues, we certainly support, the efforts to find appropriate ways to regulate and to define those things. Our interest certainly from the crime laboratory perspective is when laws are passed, we are required to respond to those laws and to provide expert scientific analysis of various materials to determine whether or not those materials are present in particular exhibits that may, or items of evidence that may be submitted to us. So our responsibility is we have to read the law, we have to look at what the law says, and then we have to tailor our analytical procedures in order to meet the requirements of the law. So as Sherry had mentioned, in 2012, when I-502 was passed, it changed the definition of marijuana from just a plant material to now something that was defined by how much THC it contains. So what that did was that moved us from basically doing a very simple analysis, which was basically microscopically looking at the plant material, identifying the botanical features, doing a simple chemical test, and we could say this material is marijuana. That was relatively easy, very straightforward to do. When the definition changed and it was now determined that marijuana was defined as a plant material that contained greater than 0.3% THC, we had to then come up with a way to do what we call a quantitative analysis, actually determine how much THC is present in a material in order to be able to say that that material was marijuana. So that change in definition forced us to have to change analytically how we approach things. So our interest here is if we are looking to change definitions in the criminal statutes, then we need to be able to know whether or not that can be done analytically, or if what is being, legislation as it's being proposed, how does that impact being able to meet legal definitions in courts of law when there are criminal matters being discussed. So that's we absolutely are 100% behind looking at this issue, but we're also recognizing that as things are written, sometimes they may or may not make sense scientifically from an analytical chemistry perspective.
Right, thank you very much. And with that, Dr. Milburn. I think you're muted still. Sorry.
It's okay. one of the things that motivated me to create Druid the Druid app was because people's reactions can be really idiosyncratic, and that people can develop tolerance to THC. So medical cannabis patients can a very high level of THC in the blood and still show little or no impairment. And one of my hopes in terms of creating Druid was that people would test themselves before they get in the car or do any driving or operate heavy machinery. And impairment is really a function of how much of the dose of how much a person consumes, but also the frequency of consumption. So that, and I think all these new synthetic cannabinoids and so on like that are potentially impairing, again, I think really need to be evaluated with a good measure of impairment. One of the really advantages of Druid that I just want to mention, it only takes 3 minutes or less. Previous cannabinoid research has focused on 10, 15-minute tests where they can sort of say, yes, a person consumed cannabis, we saw some impairment. But the question is how to determine the level of impairment. And actually a study at Johns Hopkins using Druid found that the Druid was sensitive enough to distinguish different levels of impairment from different amounts of THC that a person consumes. And so I think Druid could play a big role in this, but it's going to have to be integrated into a kind of a research perspective and also perhaps a public health perspective, urging people to actually, if they want to consume, impairing substances, to do them responsibly and give them a tool to actually be responsible.
Thank you very much. Sherry, want to hand it off to you.
Thank you. Again, I'm going to support what has been said so far. We do need to worry about controlling some things or making some limits on things. But I think the problem is we don't have enough research yet to truly define all of those things that are impairing or could be impairing, knowing that a lot of people that use things are maybe poly drug users, and all of that can impact your level of impairment. So I think it might be very difficult right now legally for us to regulate or define what is actually impairing when it comes to cannabis. I think we need to let the research play out a little while so we have a good basis for what we actually define in our own laws. From my perspective right now, I think we need to do a little bit better job at regulating some of these compounds for people under the age of 21 who are not yet legal to possess them. I think that we could fairly readily do, but I think it's quite difficult without all of the research to actually come up with a robust definition of impairing.
If I could just do a follow-up question really quickly there before we jump over to Dr. Loveridge. In your opinion, and others feel free to jump in on this, I think it's fair to say, as you noted, that it is hard to determine what's impairing and non-impairing at this point, just because indeed we don't have enough research at this point and it's an emerging area. But when we talk about age gating, from your perspective, how might we do that? Are you thinking of like this collection of THC products is in and this collection of THC products is out? If you could, and maybe I'm stretching the question too far here, but how might you pencil that out, I guess is my question.
Well, I think that there is enough research out there to show that Delta 8 does have physiological effects on people. I think for right now, pretty much any THC isomer could, in theory, be regulated for people under the age of 21. We do need a lot more research on other cannabinoids, but I think right now, things like Delta 8 and some of the other THC isomers certainly could be something that could be regulated for people that are not yet legally old enough to possess.
Just to add in with what Sherry was saying, one of the challenges, and this is why the Delta 8 has become of great interest, is again, something, when we started out with I-502, we thought, okay, well, we can identify delta 9 THC, no problem. We can come up with an easy way to quantitate that. One of the things that we were not quite aware of, and as chemists and scientists all over the country really quickly recognized, the plant is actually generating delta 9, or actually generating tetrahydrocannabinolic acid, which is converted by heat or light into delta 9 THC. So it was possible to have a plant material that had a whole lot of delta 9 THCA and very little THC, which would then have it, quote unquote, be in the hemp region of the quantity, the amount of tetrahydrocannabinol that was present. But realistically, as soon as you smoke that or heat it, now all that THCA is being converted to THC. So similarly, one of the things that folks didn't really recognize until more recently was that there is a relatively easy way to convert CBD or cannabidiol into delta 8 THC. And so with cannabidiol being all over the place, every store there's CBD products all over. In the hands of the wrong individuals, that can be converted to delta 8, which does have properties relatively similar to delta 9 THC. And so knowing that delta 9 is impairing at some level, and again, as was pointed out, the aspects of tolerance and amount of usage by people, as Dr. Milburn pointed out, we don't know what that is. We don't know what that is as far as delta 8 is concerned, but we do know delta 8 has somewhat similar properties and can be a problem. So now we have a product, CBD, which is termed as legal, not impairing, and widely available, but it can be converted into something which is impairing. That becomes really problematic. And I'm certainly part of this discussion can be how do we address that?
Right, absolutely.
I was wondering, there's the sort of the legal market for that and the illegal market for that being sold. For the legal market, is there any way to require people, the sellers, to do impairment testing on whatever they're going to sell before they sell it? I'm not quite sure legally what's possible in that regard. It's more complex for the synthetic cannabinoids or something like that would, when they're discovered, have to be tested before too many people OD on them or something like that. But for things that are sold in the legal marketplace, it seems like there must be a way to put in regulations to say, you guys got to test this and demonstrate that it's safe.
Yeah, and I think that speaks to the THC concentration, which is what we're looking at. I think if we tried to test for, and that's the question that we're trying to answer here, how do we determine whether or not that product is or is not impairing, which makes the question all the more complicated. So are we actually looking at what falls in one of these two THC buckets, things that fall below a certain percentage of THC or things that fall above? And I think we already have that in the definition of what will be cannabis in the Washington state law right now. But I think this moves even beyond into this more gray area that Sherry was speaking to, that we just don't have enough research on yet. So I'd like to pause for a moment and jump over to Dr. Loveridge. If you would like to start kind of taking a stab at or give your perspectives on how we might define what is and is not impairing. I think we've got maybe a little bit of a delay, or Dr. Loveridge, just wondering if you were interested in responding to this question so far. Again, I think there's a little bit of a challenge picking up on Dr. Loveridge's end. So Dr. Leverage, wondering if you would be interested in responding to how we might define what is and is not impairing.
I'm sorry, were you addressing a question to me, Catherine?
Yes.
Yeah,
Wondering.
I'm in this Starbucks and they're making a lot of noise, so it's really hard for. I wish they wouldn't be dragging these chairs around. So I'm really intensely listening to your conversation and following as much as I can. But I've been thinking about this ever since our preliminary discussions about what is impairing and how to determine it. And it seems to me that the number of compounds and products that are emerging after the legalization of hemp makes it really impossible to report on a scientific basis of our knowledge of what's impairing and what isn't impairing, and for whom, and at what age level, and with what degree of ingestion and method of ingestion. So we have weak science and a fast developing market of new products that are potentially impairing. And that's not a good place for law enforcement to be in. It's not a good place for legislators to be legislating directives to state regulators, and it's not just Washington. So we know that all of the states that are have legalized, and we, even if they're not legalized, but they are having a mountain of challenges on coming up with an answer to your core question of how do we determine and define impairment with regard to all these products. So I'm thinking along the lines with Mike Milburn that it's an area where much more research is called for, and the FDA has issued a letter of warning about hemp-derived products, and they said none of that has been tested and so on. So I anticipate some kind of federal guidance from FDA that'll help the state regulators determine, what kinds of research do they need to prioritize, so that we can have a pretty good recommendation based on science to the legislature on this is what we would need to be working on first. If we need to add to our list of tested substances, how would we go about testing it, and what would what would we use as a standard for impairment? And in this regard, there's a development with Mike's instrument, Druid, with Canopy of Canada. They're the world's largest medical marijuana provider, where they're encouraging their users of medical marijuana to use a Druid instrument to set their baseline, and then determine for themselves if the use of medical marijuana is impairing them. So if they're using the medical marijuana and they're wondering, should I be driving, should I be working, and so on, how long would it take for me to get back to baseline after I use it, if it is in fact impairing? If it isn't impairing, that's another issue. So we need to know something about baseline condition for people, and ingesting something that they're uncertain about, and having the ability to reduce that uncertainty for themselves. And since most pharmacological chemicals are highly variable on how they affect people, it really is a person by person self-protective measure to know, whether something I've ingested has impaired my cognitive processing. So that's my 2 cents worth at this point. Okay. I hope you can hear me better than I can hear you guys.
We can hear you, yes.
Thank you.
First, I just want to pause here really briefly and check in with Justin. Any follow-up questions for you, Justin, from that first round of discussion that you'd like to offer?
No, I think the primary thing that we probably want to scale our focus down a little bit, and if folks can address, I think we can recognize based on the comments that impairing on an individual basis is very, very difficult, and you're going to need a lot more science to be talking about responsible use and those types of things. As far as regulation and what should or should not be sold on an open market unregulated, what do you think the best way to determine which products should come in? Just like in Washington State, wine or any alcohol for that matter is considered alcohol at 0.5% alcohol by volume. So even though that amount of alcohol wouldn't impair you necessarily, it is still regulated. So do you have any thoughts on where should the regulation begin as we're looking at this issue?
Um,
Go ahead, Dr. Northrop. It looks like you're about ready to say something.
Yeah. I mean, Justin's question is an excellent question, and that's really has been the challenge, and certainly is a challenge for us. I mean, as I read through the proposed, the various iterations of proposed legislation last year, there were quite a number of places where various definitions that were put in place while trying to deal with that regulatory aspect of things of what products should we have and what should we use. It was creating a conflict with the legal definitions from a criminal standpoint. And I think that's one of the things that we would like to try to have work in this process to be able to try to find ways of addressing that such that we don't have that conflict between what the courts would define as here's an illicit material versus what the regulatory market is saying, okay, here you can have this or here you can't have this. So if we go back to that whole discussion about Delta 8, certainly we would certainly be in favor of saying, okay, add Delta 8 to the statutes. And if you have, any amount of Delta 8 in a product, it's, not considered appropriate to, for sale. Your problem is, and, as I believe as Dr. Milburn had pointed out, do we have even if you have a company that's selling, straight up CBD, this is just CBD oil, that's all it is. And they've tested it and it meets, meets all the requirements. It's CBD. It doesn't have any Delta 9 or Delta 8. The reality is somebody can buy that legally and go home and convert it to Delta 8. And so that then becomes the challenge is how do you deal with the illicit use of a licit material? And so, as we've sort of been discussing this, I think Justin had, mentioned this aspect of age gating. This was sort of something we had talked about briefly in our preliminary discussions with when I-502 was passed. Initially, it was, this has to be greater than 0.3% THC to be considered an illegal material. But it was also one of those things where juveniles, those under 21, were not supposed to be able to have access to anything. So one of the things we were able to successfully ask the legislature to do was to amend that definition so that for those under 21, it didn't matter what the concentration of THC was. If there was any THC in the plant material, that was considered something they were not supposed to have access to. And so for juveniles, all we had to do was identify whether or not the material contained Delta 9 THC. So would this be an approach that could be looked at here? It doesn't matter whether or not it has CBD or not. Any CBD product would be something that is not purchasable by somebody under 21. That would be similar to what we do with cigarettes. Now, do those under 21 get a hold of cigarettes? Sure, they do. But at least from the standpoint of the regulatory side of things, it might be that would be an approach that could be looked at. That then doesn't have us with a bunch of legislation, which then has a number here and a number there and a substance here and a substance there, which then becomes really difficult to sort of piece that whole thing together.
Yeah, and to that end, perhaps even some, I know there's some pretty lengthy scientific definitions for these products that can be a challenge, I think, from the law enforcement perspective. Is that a correct statement? Yeah. Oh, go ahead, Sherry. It looks like you're, I think Dr. Milburn, go ahead.
Yeah, I mean, I was thinking that Washington State, by setting that 5 nanogram limit on THC as evidence of impairment, has I think that's the wrong direction to go. I mean, the regulators in the state of Michigan looked at all this and said, actually, no, we don't want to specify a specific level, because there's people, you can have medical cannabis patients with a blood alcohol concentration of 20 milligrams or 40. It's because they use it every day and they develop tolerance. So I really kind of think in terms of down the road and law enforcement, it needs to be, with Druid or some other tool that measures actual impairment, reaction time, hand-eye coordination, balance, in combination potentially with a blood test that identifies, THC, you can continue adding to the list, Delta 8 and this synthetic and this one, whatever, of things that are demonstrated to cause impairment. And then when you have an actual impairment, objective impairment measure, the two of those can go together and I think, produce effective regulation. Anyway, it was my thought.
Yeah. Sherry, please.
Again, I want to second that that idea, in that really right now we need to see the evidence of impairment and not necessarily define something as what is impairing, because we don't have that information yet. So if that means Druid, if that means more traditional techniques that law enforcement has used to judge the level of impairment, that's probably where we are right now, because as we know so far, this is very dependent upon the person, their familiarity with a number of compounds, what else they may be using or exposed to. I do want to I was looking at some of the chat comments, and I do want to say that this conversion of cannabidiol to the THC isomers is a relatively simple process. It's not super effective. You don't get the best yield, but if you got on Google, you could find a dozen different ways to do it at home, including the marketing of some cannabidiol products in acidic environments, such as lemonades or ketchups. Those are known to just convert on their own just because of this acidic environment. So to say that you need a lot of knowledge or a lot of equipment to actually make this conversion, that's not necessarily true. Might not be super effective, but it is happening and people can do this at home. You get a college student with a little bit of education and some willingness to try some things out, and they're quite effective at doing this.
Thank you. Thank you. Want to check in with Dr. Loveridge. I know you're listening intently as well as you can on your end. Anything you'd like to offer? I know it looks like he has his as close as he can be to the microphone. So Dr. Loveridge, anything, microphone and speaker, anything you'd like to offer to the conversation at this point?
Okay, were you talking to me again?
Yes.
Yeah, I'm listening as intently as I can to very faint sounds, but and the Starbucks is particularly busy and noisy today. It usually isn't this bad, but so it seems to me that the observation that the law enforcement people are the ones that need the most help really quickly is a really good one. We heard many stories from people in the field about the lack of ability to meet the challenge of making, especially polydrug situations, of making that judgment of impairment. The tool that is relied upon is the standard field sobriety test. There is A-RIDE enhancement training, 8 hours training, but none of them feel really confident that that's enough training to get them there. I was able to observe 3 separate Green Lab trainings where actual consumption of cannabis products took place, and then the officers could observe the changes in behavior associated with that. And out of the all of the officers I interviewed, each one of them that took part in the training, they said this is essentially what we need. We need to have far better training, because the law is putting heavy responsibility on our shoulder to when we opine impairment, they take that very seriously and bring it into court. And so for us to opine correctly, we'd really need much better training. And whether it's Druid or some other tool, we need to give them more tools so that when they make a judgment. And I remember one officer's, he was almost crying, telling me about this. When I have someone I've stopped on the road and I suspect that they might be impaired, I have a really tough decision to make, because in our state, the penalty for impaired driving is very, very great. A lot of the people I stop can't really afford to have that kind of disruption, major life disruption. But on the other hand, I know if I let someone who is impaired out on the street, they may harm themselves or others. So you're putting me in this position. It's not fair. Give me the training I need. Give me more tools. Give me additional measures of impairment that I can use when I make this horrible judgment. It's a tough judgment. And these are people that want to do the right thing. And I didn't hear a single officer complaining about it. They just wanted more training and better tools. So I think that's all I can say now. I hope you can hear me better than I can hear you. Thank you.
We can hear you. So I'd like to turn back. We've only got, oh my gosh, 6 minutes left in this segment. Really, it sounds like perhaps the thought of this group is to move from a regulatory perspective more into concentrating on accessibility to youth. And I want to make sure that that's what is that kind of where we're thinking the regulatory focus might want to be?
Could you repeat that question, actually?
Yeah, it was kind of an observation, and that is, we've talked about the current CSA, we've talked about THC concentration, but I think what I'm hearing, and I think it was from prior discussions with you folks, and then also during this discussion, that perhaps a better approach or a different approach other than impairing is concentrating on accessibility to youth and the age gating component, rather than determining what is impairing and non-impairing. And I think that's what I'm hearing. So just a comment, observation, feedback on that. Again, from a regulatory perspective.
Yeah, I think if I understand the question correctly, I was listening very intently and trying to read your lips. So if you would look directly at the camera when you speak, it might help me discern what's going on. But I'm struck by the people in Michigan who legalized marijuana after we did, and they had a task force to study all of the options for this is impaired driving, for impaired driving enforcement. And they determined that it was a mistake to do a per se law and to put it into place because of the high variability of a reaction at different nanogram levels of THC in the blood to various people. And so they're putting all of their weight in the training of officers to opine impairment when they see it in the field, and to concentrate on going away from the blood standard. I know we have a very high a level of investment in our toxicology lab, and we want to use blood as a gold standard for our prosecution system and all of that. But I also know that every prosecutor I talked to who said, the 5 nanogram standard was a gigantic mistake. I know we wanted to have it and law enforcement wanted it, but it turns out to be a really big mistake. And I would ask them, well, explain why. It says because a lot of people are impaired below 5 nanograms, but no jury is going to convict them because there wasn't 5 nanograms in the blood. And they said, if you're an officer and you bring me this person, and they were clearly impaired by every training standard I've ever had, and you won't prosecute the case, they get mad at me. And they say, what's wrong with you? I said, I don't have 5 nanograms. You don't understand. That's how juries think. We have 0.08. We have all these other examples of what they're used to prosecuting on, and they don't like that standard. And some people have they just don't want to change from what we have, and let's collect blood, and let's train people to be phlebotomists and get the blood right away because it degrades and all that. It's just the wrong direction to go. The direction is really away from that for cannabis and cannabinoid derivatives and products and so on, because it doesn't work the same way as alcohol. It would be great if everything was just like alcohol and we could keep everything we have in place, but it isn't the case. It's much more complicated drug, and the mixing of drugs makes it even more complicated. So I don't see any practical alternative to concentrating on some way of getting to impairment per se in the field at point of arrest. I just don't see reliance on the chemistry of the blood to get us very far on public safety.
All right, thank you for that. We are at 11. Any other feedback folks would like to offer? And then also touching in with Justin really quickly before we move into the open question section with our audience.
No, I think we can move into that section.
Okay. Panelists okay with that? All right. Sounds good. All right. So turning it over to Audrey here to we'll go ahead and raise your hand if you wish to ask a question to the panel over using your microphone, or raise your hand. And I see there's been a lot of stuff happening in the chat. So Audrey, how should we start?
So Kathy, I've emailed you a list of the questions that came in before 11. If you want to take a look at those, and then we do have some. We have one hand up currently from Jim McCrae.
Okay. So why don't we go ahead and start with the chat box questions real quick, and Mr. McCrae will come back to you. And again, we do only have 25 minutes for this section. So go ahead, Audrey.
Okay. So we do have a number of them, and I have emailed them to you, Kathy, if you'd like to look and see which. I'm not sure we'll be able to get to all of them, but the first question was from Christina Phelps, asking for the panel to comment on some proposed criteria for screening specific cannabinoids for impairing intoxicating potential. So it is a rather long paragraph chunk. So if the panel is able to look at that in the chat, that might be one way to approach it. Otherwise, I can maybe reading it out may be a little difficult, but if you'd like, I can also attempt to read it out.
Yeah, it is a very lengthy question. So panelists, can you see that question from Ms. Phelps in the chat?
We could share it on the screen as well, Kathy, if that might be another way to do it.
Yeah. Well, why don't we? Are you able to, let's see.
I could share my screen if that would be
Okay.
helpful.
Why
So
don't we
do
do
you
that?
normally drive to Calgary? No, you fly.
Okay. Thank
So
you, Audrey.
I think we're getting a little bit of feedback from someone else. So if folks who aren't speaking could remember to mute, that would also be helpful. But this is the question up on the screen here. So let's see if I can get it all on one page.
Thank you, Audrey.
Okay.
So it appears that these are mostly statements, but the participant is asking for comments on these statements.
I guess I'm going to go back as a panelist on this and say we need more research. We need more research that has gone through robust review that becomes peer-reviewed and published. And until we have that, I think it's really, really hard to put any kind of specific definition together, to put numbers together if that becomes blood or if that becomes, you know, this compound in conjunction with this compound. I just haven't seen published research that really helps us to talk about all of these things that Ms. Phelps listed.
Okay, thank you.
I mean,
Others?
I mean, I would add my certainly agreement that absolutely the standards should be set by objective measurements, not self-descriptors, which is what I had in mind with creating Druid, you know, using the accelerometer to measure balance, measuring reaction time, hand-eye coordination. So, I mean, that's the kind of measurements I think need to be done to evaluate impairing substances that slow people's reaction time and slow their cognitive processing.
Yeah, this is also one of those areas where it would be really, really good to have some of our toxicology folks, you know, chime in, because there's certainly more expertise on this. I do know from having some discussions with them, you know, to Dr. Leveridge's point about the 5 nanogram per se, I know that when that was being proposed, that I believe that our toxicology folks were, for similar reasons, very opposed to that level being set. Because of a whole bunch of different things. You know, one, THC and these cannabinoids are more what we consider to be fat soluble types of substances. And so what happens is they'll go into the blood, but they get very quickly distributed into the, you know, into the lipids in our system as opposed to in the blood. And so that's it, your bloodstream gets depleted of those very, very rapidly. But as your body continues to metabolize these things, you then have a redistribution out of the fat into the bloodstream of these substances. And so you have what they call biphasic or multiphasic distribution of some of these drugs. But again, you know, both Sherry and I on the chemistry side were more analytical chemists than toxicologists. And so for us to, you know, have much comment or opinion on this really begins to get out of sort of our realm of expertise, other than recognizing that it is complex.
Sure. All right, thank you. And I think we'll just go ahead and move on to the next question that came up from, it looks like, Canlytics. Shouldn't there be a null hypothesis of no effect, and upon evidence of a detrimental effect, then look at action? It's not possible to prove a negative. Doesn't conversion to delta 8 require heavy solvents such as methanol? Is it realistic that someone could really convert CBD to delta 8 at home on a casual basis?
So the last half of that question, I think Sherry did address that, and I saw that there was another chat later on suggesting that that's not possible. Not only is it possible, we've proved it. It's very easy to do. And this is very similar to what we saw many years ago with methamphetamine. There was all sorts of, suggestions out there by, even federal law enforcement labs. Oh, it couldn't be made at home, couldn't be made at home. And then, we were just completely blown away with just a rash of methamphetamine labs all over the country, by all sorts of people, including people with very, very little education doing some very sophisticated chemistry because they read a recipe off the internet. Fact of the matter is, it can be done. It is being done. It's not a theoretical. It's an actual fact that is happening. And so to suggest that it's not is ignoring a problem which really could become very significant very quickly.
The other thing I would like to add on that is if you think people are buying CBD from the regulated market and doing this, that's not necessarily true. There is definitely a black market that exists in this state. It is very robust. People are growing on their own. People are, like it or not, people are running things out the back door of regulated industry. And so it is prevalent on the street. People are getting their hands on bulk amounts of material where they can be doing these conversions. Things are coming in from out of state. So we can't ignore the fact that there is a robust black market and people are able to do this. So if we don't have some bumpers in place when it comes to some of our legal definitions, then there's not much we can do to prosecute people that are committing these crimes or exposing our youth to some of these things that we as a society have agreed we don't want them exposed to.
Thank you. Other panelists, any other feedback on that question? All right, so moving on to the next question. This is from Amanda Duger, and I hope I said your name correctly, ma'am. Would it be hard to determine impairment just for marijuana or cannabis, as there is many who are poly users?
Well, and that actually comes back to the problem of the BAC per se limit 0.08 and the 5 nanogram limit. For cannabis, a person could be below both of those, but they have a synergistic effect and can create more substantial impairment. And again, broken record here, but that's why Druid or some kind of impairment measure is really critical to address the limitations, the loopholes.
Might have to be let in, I'm not sure.
Seems like I'm in. Let me see here. Okay, so then
polydrug use.
There's a whole bunch of feedback there. If folks could mute, please, we'd appreciate it. Dr. Milburn, please, I think we lost the last piece of what you were saying there. There was some feedback.
Sure, that I was just making the point that setting specific nanogram or blood alcohol concentration limits create some loopholes for polydrug users who could be below both those standard limits, but still be pretty impaired because alcohol and cannabis can have a synergistic effect. And that's why we need to develop some objective measures of impairment that can be used by the roadside.
Great, thank you very much. All right, moving on to the next question. This is from Paul Manzanares. And sir, I hope I pronounced your name correctly. If the acidic nature of ketchup can create isomers, wouldn't the acidic conditions of the stomach do the same and make delta 8 natural human metabolite of CBD?
I don't have any research or anything right now to talk about what the stomach acid of that would do. Realistically, what we are seeing for that conversion is already done. It's being ingested. Most of the delta 8 or THC isomer containing products that we're seeing are coming in a concentrate type form or as infused products. And so those then are generally being consumed by smoking or vaping or that kind of thing. That is generally what we're seeing. I do not have the expertise to comment on what the stomach acid would do.
I would think that's unlikely, given the fact that if someone makes brownies, they have to cook the flour in some oil or butter or something first before they make the brownie. So there's some heating process that goes through to activate that. I think if you just eat marijuana leaves, I don't believe you, or flowers, you don't get much effect, is my understanding. I have not tried that, by the way.
All right. So thank you. So Audrey, let's turn to our any hands that are raised. I think there was one that came up from Mr. McCrae. Is that correct?
Correct, yes. And Mr. McCrae, you should be able to unmute yourself. Jim McCrae, you should be able to unmute yourself if you're speaking. We're not hearing you yet.
You have to move the cursor around to get that little bar with the, so you can unmute it.
So Jim also put a question in the chat. He might be having technical difficulties at the moment. We can read it out loud if that would. And it looks like he's asking us to do that. So I'll go ahead and read it. It is
Thank you.
lengthy, so I'll put it on the screen also if that's okay.
Okay, thanks, Audrey.
Okay, so Jim asks, what are the scientists on the panel involved in the per se DUI determinations based on such minuscule levels of THC think about the consequences their tests enable and the public harms caused by such irrational enforcement standards? Do other panelists have any related thoughts? And so he's referring back up to some the levels that he included in his chat comment, which I'll just highlight it here on the screen.
I am not a toxicologist. I cannot weigh in on any scientific information on that. I am a solid dose drug analyst, so I analyze the material that comes in to try to determine what it is. So unfortunately, I have nothing I can add to that discussion.
Yeah, that would be the same here. It really is for our toxicology folks to weigh in on that.
And I do, again, the purpose of our conversation truly is to think about what we might do in terms of regulation. And I'm not sure that, I'm sure this question is important, but I'm not sure how it will help to service this conversation today. But I think this is something that we can look at in the future.
Mm-hmm.
All right, so thank you for that, Audrey. I'd like to touch on a question that came in from Caitlin Ryan, and if I may, I'm just going to go ahead and read it. Is there a danger in creating a definition of impairment before we have more research from a policy perspective? And that might be a interesting question to think about right now.
I will say, when you go to court and testify, if there isn't a basis that you are defining, so if you have no scientific basis or you have nothing backing up, I think it's really hard to defend when you are testifying on whether somebody is impaired or not, or whether you've met a legal definition or not. You have to have something behind that. So if we don't have something solid behind our use of the term impairing, it's really hard then to go and try to prosecute somebody if you don't have it. So I don't want to punt and say we need to just put, wait years to define impairing. But I think it's really hard from a legal perspective if you don't have good sound science and research behind that to defend charging someone with possession or being impaired.
One of the real advantages of Druid, one of the first things we did was to take into account the standard of the blood alcohol concentration of 0.08. Most people in the public and everything understand, oh yeah, someone's really impaired at that level. And so working with police wet labs where volunteers would come in and get intoxicated, and then the cadets could actually practice the standard field sobriety test. We were able to give in the police labs Druid to the people, volunteers, when they were sober and when they had to stop drinking with a BAC of 0.11. And so we've actually been able to calibrate impairment levels of Druid. The scores run from 25 to 75, higher numbers, higher impairment, to the the equivalent impairment for different blood alcohol concentrations. And I think any objective measure of impairment should really try to make use of that, because that's the standard. It's written. I've seen it in print that virtually everyone at the 0.08 level of concentration impaired, professional drinkers will show less impairment if they develop real tolerance to alcohol. But that's a pretty pervasive standard to use. Slowed reaction time, diminished hand-eye coordination, impaired balance. I mean, balance in the single leg stand is really important because something like a third to half the neurons in the brain are in the cerebellum, which control balance. And if you have disrupted balance, you have pretty system-wide impairment. And so that's why I keep coming back to some objective standard of impairment. I think will make a huge contribution to public safety and not be discriminatory against medical cannabis patients, for example, because there's no.
Yeah, and there is somebody unmuted there.
Yeah,
Sorry.
yeah. So anyway, yeah. I mean, antihistamines can cause impairment. You're told, don't drive after, taking this, but there's no breathalyzer test for Benadryl that people, police and toxicologists routinely do. That's why there really needs to be some equivalent standard of impairment. That's my 2 cents.
Great, thank you for that. I'm going to read one more question from the chat, and I think I saw a couple of hands go up. And I think we've heard a lot about research today and additional research that's needed. And Amanda asks, everyone keeps saying we need more research. How could this research be done? Go ahead, Dr. Loveridge. Go ahead.
Let me see if I can get my.
Whoops, you're
muted.
You're muted.
How about now?
Good.
Okay. So it seems to me that there's an observation from the Maui Conference of State Attorney Generals. Everybody has the same problems. A flood of products that we don't know whether they're impairing or not are coming forth. Some of them have been around a while. Many of them are just popping on the scene before we can even get a handle on one. There's 2 or 3 new things and synthetics and all of these problems. We can't solve this problem in Washington. We need a national consortium of people that are dealing with state regulation that can pool their resources and do the research that we need to determine whether compound X, Y, or Z is in fact impairing, and we need to share that information, and we need to share the cost of generating that research. I think the question was really good, and I saw it on the chat of how's it going to happen. Well, it won't happen because we want it to happen. We need to get something moving. We need to get a group of AGs people and regulators together and say, hey, here's our priority list. We can't do everything, but here's what we really need to deal with right now. And then here's a process that we need to set up. What will we accept as evidence of impairing? And at what level, and go from that to the next the next challenge. Then there will be a constant set of challenges. I think impairment is really tricky because it's impairment for what? Okay, it could be impaired judgment, it could be impaired physical operation, could be a number of things. All the work that we've been concentrating on has been impairment with regard to driving. What are the things that you need to drive safely, to operate a heavy machinery safely, and so on? To, if you're working in a mine, to operate the machines that keep miner safety in mind. So we have an idea of that. There might be other forms of impairment that medical professionals would say we should be testing for as well. I don't know that. That's a whole nother thing. Impairment could be the episodic impairment, or it could be incremental impairment over a long run. There's a lot of different psychological and pharmacological aspects to impairment that we're just touching the surface on. But for regulation's sake, the primary thing is driving, public safety, youth use, and so on. And we can definitely set a priority if we had a working group of regulators, state regulators, and AGs that said let's get the money we need to do this research, and let's prioritize it. If we can't jump to the research, at least we could jump to a conference on setting the agenda for research. And it seems to me that's what we need to do. That's just my view as a political scientist, watching important things that never get done. How they get done is you jump on it and you do it. Thank you.
Thank you. Do others want to jump in on that question? It was a great question. Is a great question.
I mean, one of the things I have found is that research related to cannabinoids is really expensive. It's hard for individual small little startups to do. So some kind of government funding is really important. That's how Druid supported research at Johns Hopkins through a small business innovation research grant from NIDA, from NIH. And more kind of grant opportunities like that need to be available to get this work done.
Great, thank you. Others? All right, Audrey, I think I saw one more hand go up. And correct me if I'm wrong there, but.
So we had a hand earlier, but that individual lowered their hand or left.
Okay. All right, well, we are at 5 minutes before close. If folks have additional questions, and I know there were some that were posed in the chat that we didn't get to today, please don't hesitate to send those to the rules inbox, and we will forward those on to our panelists and provide responses to you. We don't want to stop the conversation. We do have another deliberative dialogue scheduled tentatively, I will say, for June 21st with a behavioral health focus. So that is in the future. But before we close, any last words from panelists before we sign off for today? Or Justin and I offer ours as well. Go ahead, Dr. Milburn.
I was just going to say thanks for putting this together. This is an interesting discussion. Obviously a very important one.
Absolutely. All right, so Justin, would you like to offer some closing words?
Yeah, just once again, thank you, panelists, for joining us today. I think that the points, especially around research and where should the focus be around the regulation, is really important for us to consider, and I really appreciate everybody's perspective on that. And we'll be able to have several takeaways, I believe, that we'll be thinking about during the policy development and subsequent any type of rulemaking that we have forthcoming, or even legislative proposals for next year, which is still kind of a work in progress. Nothing is guaranteed, but so really appreciate the insight and the time that you took to spend with us today. So thank you.
Welcome.
Yes, thanks very much. And again, if you have additional questions that you'd like us to forward on to the panelists, we're more than happy to do that. If you can send those questions to rules, that's RULES @ LCB and we'll go ahead and send those on to our panelists. So again, just to echo what Justin said, thank you very much for spending your morning with us. We really appreciate the gift of your time today and your knowledge and expertise in this area. We look forward to continue to working with you on this really challenging topic area that weren't so sure when I-502 passed that we would ever be at this spot. I think we can agree this is advanced much more rapidly than we knew in 2012. I think that's a fair statement, unless others have another thought on that. But anyway, with that, again, thanks audience for joining us today. As I mentioned, we do have another deliberative dialogue tentatively scheduled for June 21st. Don't have a time set yet, but that panel will be focused on behavioral health perspectives on this very interesting and important and very complex topic. All right, so with that, I'll give everyone 2 days, or 2 days. I wish I could give everyone 2 days back. 2 minutes back in your day. Enjoy the rest of the sunny weather if you're here in Washington, and take good care. Until next time. Bye, everyone.
Thank you.